everyone. Welcome to a special surprise Monday stream. You know, I was on Pacer today looking for any updates on Lauren Armstrong, and there unfortunately weren't. But you know what we did find? An update in Laura Owens' parents' bankruptcy. That's right. Jennifer Giaimo has filed a 12-page supplemental response to their motion to dismiss. And she basically manages to call them liars for several pages without ever actually using the word. Anyway, we're going to be going through it. I've taken my little notes, highlighted it, and yeah, it's pretty... We get a little bit more detail into exactly how screwed they are, but let's go. All right. Oh, before that, if this is your first time here, please remember to hit the like button and subscribe if you enjoy what you're seeing here. Hello to the replay crew, and hello to everyone who's here with us live in the chat. All right, there we go. And also want to mention, if you are in fact new here, we cover plenty of subjects on this channel, and in the description of this video, you will find playlists for all the morons we cover. And while they might not all be murderers, they are definitely all stupid. So, as I said, Jennifer Giaimo filed a supplemental response. So if you remember, for those of you who don't remember or aren't familiar, the Laura Owens' parents, Laura Owen, the serial fraudster, pregnancy liar, who's facing criminal charges for all of her lies. Her parents tried filing bankruptcy last year, tried filing Chapter 13. They didn't do anything to properly execute it, meaning they failed to make the payments. They wouldn't disclose all the stuff they had to, and so it was denied. Then a few months later, or it was denied in January of this year. Then in May of this year, they filed for Chapter 11. Trying the same old shenanigans, and they didn't file any of the right stuff, and they changed their answers, which, you know, makes a lot of sense since their daughter is being brought up on perjury charges, right? This family could do nothing but lie. So the Owens had filed a motion to dismiss their bankruptcy, and that's why they claim they didn't do anything. And then previously the trustee had said, well, if you agree not to file for 1 year. And turns out that's probably not enough anymore. So let's get into it here. And I will try and keep the chat on the side. Okay, so I've highlighted just so we don't read every single word on here. But, okay. The United States trustee, buying through Underside Counsel, files this supplemental response to the motion to dismiss case filed by the debtors, Elizabeth Ann Naylor and Ronald Stephen Owens. All right, the background, like I said, they filed Chapter 11, or Chapter 13. Chapter 13, oh God, what is this? The Chapter 13 was dismissed on January 26, 2026, based on the debtor's failure to comply with the recommendations of the Chapter 13 trustee with respect to the debtor's Chapter 13 plan. Debtors filed this case, where they're filing Chapter 11, on May 22nd, 2026, less than 4 months after the Chapter 13 was dismissed. On June 8th, 2026, the debtors filed their emergency motion to continue the Section 362 stay, which the which the trustee objected to. And the next part, they basically incorporate everything they said in that objection, which we heard on the call, into this one, as if it was here. And the court denied the debtor's motion to continue the stay, because what they're doing is they just keep filing this emergency bankruptcy stay, because their house is about to be foreclosed on. On June 24th, 2026, debtors filed their motion to dismiss case. Court withheld ruling on the motion to dismiss case and ruling to dismiss, and directed the debtors to produce certain documents, including an accounting of certain GoFundMe funds. Debtors produced documents and appeared for examination under oath at the meeting of creditors pursuant to Code 341 on July 16th, 2026. That was the hearing That was over part 2, 3, and 4 in previous streams. The one that was like 3 hours. Debtors also amended several schedules in Statement of Financial Affairs. The U.S. trustee now files this supplemental response to the motion to dismiss, requesting that the case be dismissed with prejudice with a 2-year bar to refiling bankruptcy in any federal bankruptcy court. So the motion to dismiss is going to be decided in 3 days. And so they're putting their position out there of what they feel the court should do. So in advance of the hearing, the question that the U.S. trustee has evaluated is whether the creditors are better served by conversion to Chapter 7 or by dismissal with a 2-year bar to refiling. The U.S. trustee has concluded that dismissal with a 2-year bar is the superior outcome. And people might think, why is that? Well, we're going to explain it. Investigations raised serious and unresolved concerns about the accuracy of the debtor's sworn disclosures. However, in light of the debtor's current financial status, dismissal is preferable to conversion. Well, why would that be? Because there is no meaningful pool of collectible, non-exempt assets for a Chapter 7 trustee to liquidate. Basically, what she's saying is, with not so many words, is there's nothing for me to trustee over. There's nothing here for me to distribute to all the creditors. These are broke. And exactly, Katie Gate. So I guess that face-to-face hearing went well. No, I don't think it did at all. Anyway, conversion would cause delay for creditors, an administrative expense for the estate without the likelihood of any return. So in other words, if we convert it to Chapter 7, then they still have the bankruptcy protections against their house being foreclosed on, versus if we just dismiss it and say they can't file for 2 more years, then everyone that needs money from them can file. They can essentially, foreclose on the house, take it back. Because there's nothing to pay it off. From TIFF. Oh, a TIFF raid. But I do like this document. I probably wouldn't have read this as a stream, but we get the full breakdown of all the lies, right? And Jennifer was putting this in there and loving doing it every time. The U.S. trustee concerns regarding the debtor's sworn statements, Section 3. Across 3 sets of schedules, the debtors have sworn to statements that cannot all be true. And don't pay too much attention to the coloring here. This is just, for me, it's different subjects, right? Ownership of debtor's residence was sworn at 50%, then 100%, then 50% again. Yeah, I guess you could call that 3 lies. Well, maybe we just call it all 1 lie by subject. Unsecured debt was sworn at $511,327.21. Then effectively at zero. Effectively zero. Then at $729,875. The debtor's animals were valued at $1,100 in both prior filings, described as 7 retired horses and a dog. While the recent amendments value the Quartet Farms LLC interest at $62,751 and values a single pony at $60,000. Sorry, let me mute something here. Sorry. So okay, here's another lie. The dog is listed as an asset? Somebody would have to tell me. But are you required to list your dog as an asset? Will they sell your dog? They shouldn't call Laura. They shouldn't call Laura a dog. Yeah, that's rude. Where else we got? Okay. Shared screen, moving screens around. So how we got 1, 2, 3 inconsistencies so far. by subject. Debtors previously answered no to Schedule G, asking whether any leases were outstanding as of the petition date, but just recently disclosed a 12-month lease of the pony to a third party. 4. Neither prior filing disclosed business income, yet the Statement of Financial Affairs Amendment, how do I get that to stop happening? The Statement of Financial Affairs Amendment reports gross income of $40,785 for 2024, $81,000 for 2025, and $26,000 for 2026. Neither prior filing disclosed GoFundMe income. Yet, the debtors had received more than $100,000 from GoFundMe donations. The amendments recently filed now disclose the receipt of $131,590 of GoFundMe funds in 2025 alone. So we got 1, 2, 3, 4, 5, 6. All right, item 7, that's a problem. Item 13 of the Statement of Financial Affairs asked for all gifts over $600 per person within 2 years before the petition date. Twice the debtor stated under oath that there were none. But the recent amendment now discloses $19,608 in gifts to Laura Owens, their daughter. No, Purple Pixie Dust, they aren't. They have nothing left. That's the point. They spent it all. Debtors swore twice that they had made no payments on a debt owed to anyone who was an insider within 1 year before the petition date. But the recent amendment now discloses $21,056 paid on behalf of debtors' daughters, Sarah Owens Navarro, in May 25th, March 2026, and May 2026. She's going to go through what they actually have and why bankruptcy doesn't matter and all. Until the recent amendments, debtor Naylor's membership and manager interest in Good Luck Shop LLC, that's the fourth business, I guess, I couldn't remember for somebody who was asking the question, went undisclosed in both cases, even after the Arizona Department of Revenue raised it in the Chapter 13. Well, that's not good. All right. The recent amendments also disclose, for the first time, $7,000 in cashier's checks, Charles Schwab accounts, and $10,250 of antique furniture, while a monthly in-home care expense of $2,400 and a monthly horse insurance expense of $425 each appeared in one filing and vanished from the others. How many times can you this up, you guys? So 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14. 14 inconsistencies by subject. Statements of this character, if proven to have been made knowingly and fraudulently, would support an action to deny discharge under Code Section 272A. That code section is just where the debtor is trying to say, okay, like, I want to dismiss it, but then you can do it with prejudice and bar them for longer. The U.S. trustee does not abandon that view, but pursuing that remedy would not benefit the creditors. Conversion would yield no distribution. Section 4. Convert or dismiss whichever code section directs the court on a finding of cause to convert or dismiss, quote, whichever is in the best interest of creditors and the estate. Conversion satisfies that standard only if a trustee would have something to administer. Here, a trustee would not. The debtor's residence is secured by liens exceeding $1.9 million against a value the debtors themselves place between $1.5 and $1.57 million. With a first position arrearage above $191,000 that continues to accrue. There is no equity, and a trustee would likely abandon the residence, meaning I'm not going to sell it because what's the point? It's only going to get that creditor specifically part of it back when they already own it. They're the trustee of that asset unless the bankruptcy court steps in. The animals present no value for creditors for a different reason.
Son of a bitch.
I just love her just all over them in a way that they would not appreciate. Whatever the pony is worth, and the 60,000 figure is the debtor's own estimate, this state would have to take custody of a living animal and expend estate funds on shelter, food, and maintenance. Those costs, including boarding charges, feed and supply purchases, veterinary services, and association fees, aggregating $38,500 in horse and farm expenses over 18 months. You could see where their money went. Just pissing it down the toilet. A trustee would need to fund from an estate with no cash, would need a specialized broker, and would do so while the animal remains subject to a 12-month lease. The 7 remaining horses are described in every file as retired, which is to say they have no market value and cost money every day. Sale basically would meet or exceed any proceeds realized. The amount to keep paying for the horses to keep them alive would cost more than whatever they're gonna be sold for, and that's basically the tale with all of their assets. There are no other apparent. I mean, just that. I think. Side note here: the horse thing really pisses me off. The horse equestrian everything. That is for somebody who has crazy amounts of money to burn. They don't have crazy amounts of money to burn. How is it so hard for them to understand, hey, yeah, we know you like horses, Laura, but they're really expensive and we don't make any money off of it? What do you mean? They're disposable to them? I mean, the Owens, they can file. Here's what's essentially happening. The bankruptcy court is arguing, no more protections. We're going to discharge it. You can't file for 2 more years. And everyone that you owe money can now come in and start to collect. So there's no relief by the bankruptcy court. And even if the judge doesn't dismiss it, they would say, well, there's fraud, right? But in order to help the creditors remove all the bankruptcy, let's dismiss this right now. The bank can step in and take the house. If they want to try and save their house somehow, they can somehow find somebody to buy these horses or give them away for free so you stop paying money to feed them. I mean, they still got these horses while they're hemorrhaging cash. Jesus. Anyway, there are no apparent other non-exempt assets for a Chapter 7 trustee to administer. Yeah, this is what state they're in. The amended schedules disclose Schwab holdings of $831 in retirement accounts of $172 and $102 that are excluded or exempt. They've got what, $1,100 in their retirement accounts? They're down in the fill. An income consisting of exempt Social Security and pension payments, meaning it's exempt. You can't garnish it or whatever. I don't know the full rules on that. But what would Laura do if she did not have the horses to show when she's supposed to be in court? Yeah. How would she compete for like 6th place? She wasn't even that good. That's the other ridiculous part. It's not like she's like nationally known as a top equestrian. She's finishing 7th in like local shows. Like competing against, 14-year-olds. What? They're hiding crap where? The trustee went through all their bank accounts. Remaining personal property is largely exempt under Arizona law and worth little net of costs of collection and sale. Meaning, even if we took the rest of the shit we could, we're not gonna bring as much in as it is for us to sell it. Household goods held in storage secure roughly $26,000 in unpaid charges. Meaning, whatever they put in their little storage unit, probably furniture and I don't know, whatever household goods. Well, they owe $26,000 on it, so they aren't getting that back. The insider transfers described above are the only theoretically available asset as avoidable transactions. But realizing on them would require adversary proceedings funded by an estate with no unencumbered cash. Transferees are uncollectible, or it may determine that it's uncollectible. Basically, yeah, we could do some court hearings and try and get the money back from the people they gave the gifts to, but those people being Laura Owens, we're not going to get that money back. Collection from Laura Owens is already called into question by the fact that Laura Owens recently filed her own Chapter 7 filing in this court, which was ultimately dismissed. Offshore accounts? I feel like you're just throwing out buzzwords. If I may, please. These morons are not clever enough to hide money by the fact that they get caught almost immediately. Part 5. The GoFundMe funds are beyond recovery. The U.S. trustee has particular concern about the GoFundMe proceeds. They received $132,000 in GoFundMe payouts into a single account, $109,290 of it in January 2025. The campaign solicited the public. I mean, no, this isn't new, obviously. The campaign solicited the public reference to debtor Owens' Parkinson's disease, history of cancer, and cardiac condition, and included the representation that his medical struggles had taken a toll both physically and financially. Over the 18 months reviewed, healthcare and pharmacy disbursements from all 8 accounts totaled $17,209, roughly 2.7% of net spending. Let me tell you why I'm laughing at that one. That is not even enough to write off on your taxes, people. You have to meet a minimum threshold of medical expenses as part of your income to be able to deduct it or exclude it. No. Okay, everyone, calm down. It's not a red herring where they're being caught. These morons lied to prop up their image, saying, oh, yeah, we're successful business, all this stuff. They didn't want anyone to know about the GoFundMe, so let's not mention that one. And then, we don't want to show that we're giving our daughter money, right? We don't really want to get all in our business. But then when they were asked, well, why didn't you didn't put any of this down on the paperwork, they would rather leave it off than show that they only made X number of dollars from these stupid businesses that lost money, than have to just be honest and say, yeah, no, this is what it is, because they don't want everyone seeing how much they're spending on shit here, such as over the 18 months reviewed, healthcare and pharmacy. Oh yeah, I read that. Disbursements from all 8 accounts totaled $17,209, roughly 2.7% of net spending. And people think they're not relying on just her. Remember, Jennifer brought up the Wells Fargo account that she hadn't declared, because they have their own way of researching stuff, which is how you catch them in lies. In the period, discretionary spending totaled $191,000. That's where their money went, just on bullshit. In the period during which the funds were deposited, $118,000 was dispersed, including $61,654 of mortgage payments, thousands of dollars of consumer credit card payments, Macy's, right? $44,375 in capital contributions to the debtors' limited liability companies, aka their businesses that failed, that just burned money. So one of these being the horse barn that's just burning cash. They're just they're just businesses that do one thing: burn cash. transfers to their adult daughters, retail and online shopping, food delivery exceeding $1,200 per month, restaurants, subscriptions, and travel. William Phipps. I declare bankruptcy!
No, God! No, God, please, no! No!
Thank you for that, $9.99. Those facts raise a serious question whether donors received what they were promised. She's talking about the GoFundMe donors. But this is not a question the U.S. trustee can answer here. The remedy available is to deny discharge. A judgment denying discharge would return not a single dollar to a donor, would create no fund, and would not adjudicate whether the representations on a fundraising page were true. So you're basically saying if you want to get your money back, or if you're an idiot that donated to him and you feel like you were lied to, and you want to get the money back, that's up to you. You got to hire your own attorney. We're not doing it for you. Moreover, based on the U.S. trustee, I mean, yeah, their GoFundMe is still open, but it's really on the people donating to it. Anyone donating to it, they're just as dumb as these people. Yeah, they're broke. Therefore, moreover, based on the U.S. trustee's review of recent bank records, the GoFundMe funds have been fully expended. Oh, no. And the accounts carry nominal balances. Therefore, recovery of any funds would require multiple preference actions by an estate that lacks unencumbered assets to fund such lawsuits. Yeah, we don't have any money to get. We're not going to do all this work with no money. But how much do they want for the dog? That's the question. I don't know, Robin, if you saw it earlier. Do they take your dog in bankruptcy? Will they sell it? Part 6. The best interests of creditors and the estate favor dismissal. If the case is converted, creditors will be relegated to waiting to pursue their rights, likely standing to receive nothing from Chapter 7 liquidation. A contested Code Section 727 action would then require discovery, depositions, motion practice, and trial. If they had to contest the dismissal with prejudice, is what this being. I'm probably not saying that right. Normally, you would have to prove, argue it in court at a trial of why it should be dismissed with prejudice. But here, they're agreeing to it with 2 years, supposedly. In response to a Code Section 727 action, the debtors would likely. Yeah, here we are. Do you think they're lying, Jennifer? I don't know. Let's see here. In response to a Code Section 2727 action, the debtors would likely attribute false statements to prior counsel and to debtor Owens' documented illness, and would likely argue that the amendment's evidence and intent to correct rather than conceal. So we can kind of get an idea of what happened in that meeting potentially, because debtor Owens' documented illness, that's the first time we've heard that called out, I think. Oh, yeah, he's so sick and we don't have time to do it. Imagine all the bullshit she was saying. And there, well, you got to understand, my husband's sick and, that takes up a lot of our time. It's like 20 hours a day for me to do it. So I couldn't, I didn't have time to prepare all these things. I'm not a lawyer and it's very complicated, which is why I'm trying to withdraw. And success would still yield no distribution to creditors. A Code Section 77 judgment would leave creditors holding exactly what the dismissal gives them now. Okay. More specifically, the code action because of them filing in bad faith. Judgment would leave creditors holding exactly what the dismissal gives them now, i.e., claims enforceable under state law only a year later. And that's exactly the point. If we don't dismiss this, it's going to hurt one group, the creditors, because they're going to have to wait for a year. Under dismissal, creditors act immediately. The 2-year bar assures that those remedies cannot be interrupted again by a third bankruptcy petition filed on the eve of a sale. Meaning, I know they're going to do this again. Creditors are better served by remedies they may exercise today than by the prospect of a judgment that is neither assured nor remunerative. Remunerative? I thought it was remunerative. Whatever. What do I know? Part 7. Cause exists to dismiss for bad faith, which also supports the 2-year bar. Cause exists independent of the debtor's own request for dismissal, and the same cause supports the 2-year bar on refiling. Bad faith is cause for dismissal with prejudice. And there's a whole bunch of case citations in here, but as she says that she previously outlined in her stay objection on docket number 37, here are the reasons, just in case you forgot, Judge. 1, the debtors made numerous misrepresentations in their pleadings in this case and in the Chapter 13. 2, the history of the debtors' filings and prior dismissals show a complete disregard of their basic obligations as bankruptcy debtors, including failing to file and produce tax returns and failing to cure substantial plan payment arrearages. 3, the sole purpose of this bankruptcy filing was to halt an imminent sale. 4, the debtors demonstrated egregious behavior, including failing to appear at a scheduled initial debtor interview, in this case, and failing to produce to the U.S. trustee standard documents required of all Chapter 11 debtors until ordered by the court to do so. And even then, they didn't do it. What they came up with was just like, I mean an effort. So then this is all talking about why, 180-day default, it could be longer than that based on case law. A dismissal with prejudice cannot be avoided simply because the debtors themselves seek voluntary dismissal. In this case, a 2-year bar to refiling is reasonable and proportionate. The debtors have filed 2 petitions in 10 months, each filing interrupting a creditor remedy. And the second filing followed a dismissal based on deficiencies that the debtors made no effort to cure. 2 years is long enough for creditors to complete their remedies without interruptions, and not so long as to foreclose relief should a genuine need later arise. AKA, 2 years is going to be long enough for the creditors to liquidate all their shit, everything they have, take the house, everything from them, get whatever collateral they have back. And but if they do have problems after the 2 years and they really need to file again, which they might, they can go ahead then. They can try it again. Part 8. Debtors agreed to do dismissal with a 2-year bar to refiling. Counsel for the U.S. trustee has conferred with the debtors regarding the relief requested herein, i.e. dismissal with a 2-year bar to refiling. Now, what do you think their response was? Debtors stated they will agree to that relief, but dispute any factual assertions in the U.S. trustee's supplemental response. Oh, you mean like she said you were going to do up here? Where? Yeah. The debtors would likely attribute false statements to prior counsel and to debtor Owens' documented illness and would likely argue that the amendment's evidence and intent to correct rather than conceal. Yeah. What is with this family? They can never admit that they've lied. Wherefore, the U.S. trustee respectfully requests that the court dismiss this Chapter 11 case under 11 U.S.C. with prejudice to the filing of any bankruptcy petition by either debtor from 2 years from entry and grant such other relief as just and proper. All right, let me see your comments here, because I'm not quite following some of the statements being made. Teresa said, every worst case scenario I dreamed up early has come true. Never let someone pop your hopium balloon. I believe justice is slow, both in the courts and personally, but justice prevails. Oh, you're saying you wanted the worst case scenarios for them. Got it. I thought you were saying worst case scenarios, and you know what I'm saying. What is a lie other than just an unproven truth, Joe Kate? No, that would be called a theory or a conjecture. A lie is a provable falsity. Do I think they believe their own bullshit? No, I don't think they believe it at all. They know they're lying. And but they also believe that they're smart enough to sell it, because if they never admit to lying, so can creditors sue them? Yeah, absolutely. That's what, if it's dismissed, they can foreclose on the house and they can sue them for whatever garnishment is available. I don't know how that works with the pension and the Social Security. I know there are limitations to that, but I don't know. But either way, doesn't sound like there's going to be any real money left for their dumb daughter. I read on Reddit, their mortgage is 8%. Ridiculous. You get a $1.7 million mortgage at 8%. Yeah. You're just begging to be blown out. Yeah, Laura Owens may actually need to get a job. Poor Laura. Oh, I don't have it here. Steve called me a dumbass. Moron. There is no other word for her in the family. You are dumbasses. You are morons. No, there's no Lauren tonight. I don't have anything ready. Sorry. This was just a spur of the moment because I saw a posting. Anyway, thank you for being here. Hope you have a great rest of your evening. But we will try and keep, if we see anything from Lauren, whatever. I'm going to be going down to Seattle the next couple days, so I won't be as home as early, but check out anything there. But anyway, YouTube believes that you will enjoy this video right. I always get this wrong. Right over here. So why don't you go check it out? Right? Kiss your fingers. Bye.